Okay. Hi, good afternoon. Oh, we started again already. Okay. Okay. Good afternoon. We wanted to come together today and offer all of you some insight and some information that you can take with you on this case, this landmark case that was just entered into called the Johnson and Johnson versus Lewandowski. And so today I have my colleague Beth Allen. She is ERISA counsel. She was formerly with the Department of Labor with EBSA as an investigator for over 5 years, and then she worked for a decade with NFP as vice president, benefits compliance and counsel. So, Beth, thank you so much for being on today's call.
Thank you for having me, Sarah.
Yeah, so let's get into this case. This is a really big case, and so I'd love to hear your thoughts as to, at a high level, who is this plaintiff and why is she suing her former company or her current company, Johnson and Johnson?
Sure. So the plaintiff in this case is actually a participant in Johnson and Johnson's plan. Okay. The case is brought and styled as a class action, but she is the one that is bringing the case. And basically, what she's alleging is that the Johnson and Johnson plan fiduciaries essentially caused her to have to pay too much money for prescription drugs that she was receiving through this plan. Very specifically, we know that she had a cancer diagnosis. So as we all, I'm sure know, cancer drugs can be some of the most expensive drugs out there. But the argument basically of the lawsuit is that Johnson and Johnson had a fiduciary obligation to make sure that their employees were paying the least amount possible for these drugs. And so that's the argument and kind of why we're here.
Do you know why she is bringing this case at this point in time?
So, honestly, I think this is a perfect storm as far as timing of what is going on with the industry, what is going on with regulation, right? And so we have seen these type of lawsuits on the retirement plan side at this point for a decade plus, right? So we're years and years into this type of, let's say, excessive fee litigation on the retirement side. But on the health and welfare side, interestingly, we're just now maybe a decade into, let's say, enforcement on healthcare plans by the DOL, as well as that retirement, plaintiffs bar realizing that, oh, health and welfare plans could also potentially be sued and brought into this type of litigation. And the hope is that it's going to result in a lot of money to those plaintiffs' firms, right? But I think it's really just a timing situation where we now realize finally that health plans are also going to be subject to ERISA and the fiduciary obligations that we get there.
Yeah, absolutely. And so, in your opinion, why is this particular case different, or is it different from prior cases brought, uh, you know, under the fiduciary duty and a breach of fiduciary duty? Why is this case different than maybe past cases that we've seen?
Sure. So obviously, I kind of already alluded to the idea that the cases that we've seen for the most part have been on the retirement side, right? And so
Right.
this is different strictly because of the fact that we're seeing this on the health and welfare side kind of for the first time, right? We've had a few cases that have already been filed, but on the health and welfare side, as far as breach of fiduciary duty, this is just a new concept that we see that there, being a chance for litigation, basically. I'll also point out that obviously with the timing of the CAA or the Consolidated Appropriations Act and this conversation around transparency, I think the timing there is apropos for employers to be looking at their health plan as well from those terms. And then also just from society at large, we're talking a lot about transparency, but also specifically about PBMs, right? So pharmacy benefit managers and the cost of drugs, right? So we are at the point where we realize that the largest cost to employers and employer health plans are those pharmacy drugs, right? And so we see that states at this point have put out a lot of legislation trying to regulate PBMs, right? The federal government is considering legislation to curb, and require things of PBMs, right? Because we all know that drugs are very expensive. And so I think that this lawsuit coming out and basically alleging that the cost of the drugs under the plan was too high, and that the employer has the obligation to do something about that is just kind of a function of what is going on in the industry as well as in society at large. Now, I think it's different because of the fact that what they're kind of alleging is that this employer knows or should have known that they could get the drugs for cheaper, right? Which is kind of different under ERISA because, frankly, ERISA and the DOL don't really attack, let's say, a plan sponsor from the standpoint of them having the employees pay too much. What they are generally going to have an issue with is when the employer does something that is imprudent, right? And so what
Right.
that speaks to is the process behind what the employer is doing. And I think that the retirement cases that we saw really did attack that process and whether or not the process was prudent. Whereas this case was slightly different in that it was just, no, the plan could have paid a lot less. And so that was kind of just how they felt like there was a breach of fiduciary duty. I think the plaintiff's bar and the defense bar are going to fight that out from the standpoint of just the cost of the drugs. But I think the conversation around prudence and whether or not employers are acting and doing what they should do from their fiduciary obligation is a conversation we're going to continue to have.
Yeah, absolutely. I mean, as a result of the CAA passed, for those who will remember, back in late 2020, signed into law by 2021, so kind of at that turn of the year, we saw kind of creeping in almost under the radar significant changes to the way health and welfare plans are, viewed from a standpoint of their fiduciary duty, and ratcheting up that, I guess, enforcement or that priority to be sort of on par with the retirement plan side of things. And so I think this caught a lot of folks in the industry and even employers who really didn't think about their plan, sponsoring their plan and being a fiduciary. I think it kind of brought in this significant change that we all didn't really realize until, we're talking about compensation disclosures and having to review our contracts for gag clauses, and really bringing to the forefront this fiduciary process that has really always been there, but now it's brought it to the forefront for health and welfare plans, just like the retirement plan benefits. And so, um, do you think specifically for this case that the CAA legislation and subsequent regulations have brought in have allowed these plaintiffs to come in and bring this case where they maybe wouldn't have in the past? Like, what are your thoughts on the CAA impact?
Sure. So I think it's interesting because I definitely think that there was an impact there just from the standpoint of the CAA coming in and being a changing tide, right? But interestingly, they didn't make any of their arguments having to do with anything under the CAA, right? The argument was based on basically solely ERISA and the fiduciary obligations that that employer has. And I think there are reasons for that. Frankly, we just got the CAA requirements. The CAA focused really on reporting and disclosure, right? And so we saw these requirements to report the cost of pharmacy drugs and to disclose to your participants certain information about what things cost under the plan in real time and before they're receiving the services under the plan. And really, we're just now getting the data from that, right? And so I think that this lawsuit kind of, again, it didn't mention CAA, which was interesting, but I think that they are mindful that that data is out there now, right? Because of things like the CAA. And so I think that although it wasn't mentioned as a specific part of kind of the way that, let's say, J&J didn't do what they were supposed to do, it is a part of that discussion. And I think that it also points to the fact that employers who just meet the requirements of the CAA and just do, let's say, the RHTC reporting and do the required, just make sure they have the disclosures, just doing that is likely not enough from a fiduciary standpoint. And so I think we kind of need to kind of turn that corner from the CAA and realize, hopefully you are compliant with all of the CAA's mandates at this point, but now we need to be looking further down the road as to what you're supposed to do with that data once you have it.
Yes, absolutely. It's not just about checking the boxes of getting this disclosure done or this submission uploaded into CMS. While those things are incredibly important, we have to take a few steps back and really look at why this is even being brought up or is such a priority on the legislative side in the first place. And because of the high cost of drugs, the high cost of care across the board, this one particularly looking at pharmacy benefit costs, which, as we all know, is a huge priority um, for legislators out there. But taking a step back and really looking at what does this mean for employers going forward? Let's do that again. So taking a step back and asking the question, because we know most watching this video are going to be asking, what does this mean for me? I'm an employer or I work with employers. What does this mean for me? Am, what specifically should employer plan sponsors be looking at in light of this case and in light of the CAA and in light of just this is something we all have to deal with and we really have to focus on what this is actually telling us that we need to be doing. So, what are your
Right.
thoughts on this?
Okay, so I have three specific thoughts. First, for employers, obviously understand that you're a fiduciary on your healthcare side, right? And don't get me wrong, there's blame to go around here. I think the DOL not really enforcing too much on the health side kind of lent itself to this. But by and large, there's a lot of employers out there who will tell you that on their health, that they know on the retirement side that they are a fiduciary and what that requires. But then on the healthcare side, they'll say, oh, well, we're fully insured, so we're not a fiduciary.
Right.
Or, oh, we're self-funded, but the TPA handles claims, so we're not a fiduciary. And that's not true. An employer is always going to be a fiduciary of the plan that they sponsor, and that's whether it's on the retirement side or the health and welfare side, okay? Now, for employers who have, let's say, a TPA who is doing those claims, then yes, that claim fiduciary is also going to be the TPA, but that does not absolve the employer from actually having a fiduciary obligation, okay? So that's the first thing that I want people to take away, or employers to take away from this call, is that understand that you are just as much a fiduciary on the health and welfare side as you are the retirement side, okay? The second thing that I would say to employers on the health and welfare side with this is that you're going to need to take the steps to actually do fiduciary due diligence or governance on the health and welfare side as well, right? Sarah, I'm sure you can attest to the number of employers who on the retirement side have a fiduciary committee, have a charter for that committee, have rules around what that committee needs to do, have education that those committee members need to do on a periodic basis. But then on the health and welfare side, they do none of those things. That is not going to be acceptable going forward. Okay. It's no longer going to be enough that you have your broker come in and kind of give you, let's say, some tips on compliance and things that you need to do, but doesn't actually set up fiduciary best practices. Okay. And so I think that's where some of our practitioners, for example, ERISA attorneys, and even some of our benefits compliance professionals are going to have to come in and help employers stand up fiduciary best practices on their health and welfare side as well, okay? And then the third thing that I will say, specifically having to do with the CAA and just transparency, and we kind of alluded to it already, but the idea that simply checking those compliance boxes that you mentioned just is not enough, right? Employers should now be looking on their health and welfare side to take those, for example, service provider compensation disclosures and actually determine, are we paying, too much in fees, right? Are the fees reasonable? They should be having that next level conversation that the legislation is designed to encourage them to have, right? And I see a lot of employers who are just saying, okay, I did my RxTC reporting. I, made sure that employees had access to the costs under the plan. I made sure that I at least, collected the broker disclosures that I was required to have. But then they just kind of put them in a file and didn't do anything else. They're going to have to do more than that. And I think that definitely a lot of the service providers in the space are going to have to assist employers in doing more than that.
Right. So going through a fiduciary process, a sort of prudent process is what I read a lot in this case. And they were, claiming that they should have done a more prudent process. And as a result, if they had gone through a more thorough process to look at the claims, look at the particular costs of the drugs, which I'm sure they had this data, they would have saved the plan and the participants millions of dollars, not only in the prescription drug arena, but also in the way that it impacts the cost of their insurance, their copays, their deductible, out-of-pocket maximums, the coinsurance. So it does affect the entire cost of the plan if you've got these outrageous costs for the care itself or the prescription drug itself. So I think overall, what you're saying is, and I agree with you, is even smaller employers that sponsor a fully insured plan or a self-insured plan should be conducting a thorough, prudent process because they are a fiduciary. They are responsible to monitor their service providers, examine costs, and so forth. And that just simply isn't happening to any significant degree. And so, can you give any just quick practical tips for, say, an employer who has maybe 100 to 500 lives. They're looking at this case going, what can I do differently? We try to quote different PBMs and stop loss. We look at claims data, but what else can we be doing as far as making sure we're really addressing our fiduciary duties?
So, kind of, I already mentioned the idea of just fiduciary governance and due diligence, right? One thing that I will say, and this is just kind of a high level concept: document, 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 right? Even employers who kind of will take, let's say, additional views into the information that they're receiving, right? So let's give the example of renewal. At renewal, employers will receive information about kind of the costs under their plan in the previous year, right? And the broker is good for making suggestions to potentially help them to decrease the costs. But a lot of employers kind of stop there. They don't actually document the steps that they took to review that information, right? They don't document, let's say, the choices that they made and why they made the choices they made to potentially change the coverage under their plan to make it more effective for employees and to potentially bring those costs down. And so, first of all, we want to document everything that you are doing, right? And I think that that's one of the things on the health and welfare side that we definitely need to do better about. But in addition to just documenting the decisions and the things that you're doing, I think it's important that employers understand that, employee complaints on these things are also important things to handle and to deal with, right? And so, I think that the service provider space does a good job, or does a better job now, of even asking employees what they think about benefits, right? And kind of doing surveys of their participants and kind of how they feel about the plan. And I also think it's a good idea for employers who are doing that kind of thing to take that information and try to do something with it, right? Like, if you do a survey and the vast majority of your employees are telling you that they don't think they get a benefit out of their plan, then as an
Mm,
employer, you probably want to be taking some steps to make some changes, so that they start to feel more comfortable with the costs under their plan and kind of what, the benefit that they're receiving, right? Because one thing about this lawsuit that is clear, on the retirement side, we saw the plaintiffs bar go after those very large employers first, right? It's
right.
obviously J&J, 130,000 employees, I believe. But then after a certain amount of time, the employers that they started to go after became smaller and smaller, right?
Mm.
And so the reality is that I think even down to the small, fully insured employer, you should be taking any kind of feedback that you're getting from employees, taking that seriously and doing things, and going to your service provider and asking if there are additional things that can be done, right? And then the last kind of final tip is for employers to actually read everything, right?
Mhm.
And I think a part of the J&J conversation and the plaintiff's complaint also alleged that there were some conflicts of interest there, right? And so, for
Right.
example, J&J got named, Aon got named, Express Scripts, and the reality is that employers have these service providers, and potentially now they know that they're getting, let's say, compensation from different places, but they don't necessarily recognize that the concern there is ultimately one of conflict of interest, and whether or not you have service providers who are recommending certain things to you that are not actually in the best interest of the plan participants and beneficiaries, and are actually things that are going to get them paid more, right? So that's a big part of the lawsuit. And I think that employers need to also be reading contracts, understanding compensation structures, and knowing if there are conflicts of interest, that they are getting some kind of assurance from their service providers that they're still going to do things in the best interest of the participants and beneficiaries. So those are some kind of tips that I would recommend really for any size employer, right? Document, please document, right? Take your employees, comments about the plan seriously, and then read everything and know kind of the relationships and know if there are potential conflicts of interest and how those are dealt with. And I think those are steps that any employer can take.
Yes, those are great tips. And I think that goes well beyond what has been done in the past, especially this conflict of interest. I did find that interesting in this lawsuit that there being Johnson and Johnson. I think basically what was alleged or what has been brought up is they're a large healthcare, organization, and they should have had a better process to identify these high cost drugs. And are they in fact, receiving some compensation from this? Are they benefiting from those costs? So that's very interesting. I know that that's not normally the employer situation, but it's definitely something that does come up in the industry, and it could come up in the way of, a large organization receiving bonuses for placing business with certain TPAs or placing business with certain PBMs, and they get a portion of that. So that to most people seems like a conflict of interest that should be examined carefully. And I think that kind of thing may be even more interesting to maybe the Department of Labor or whoever are in lawsuits are brought because they see these clear conflicts of interest. So let's talk about the broker. So a lot of brokers are going to be watching this and they're wondering, first and foremost, are they a fiduciary? And this could be broker, consultant, however you kind of position yourself. First question to you is, are they a fiduciary? And if 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 not, when do they become a fiduciary of the plan itself? Could they be named by name in one of these lawsuits,
Yeah.
as this employer was by name? And what is their role in the plan fiduciary process, their own duties? How can they help their clients? So just thinking about it from a broker's perspective, what would you say?
Sure. So most of the time, a broker would not necessarily be a plan fiduciary. And I say that because ERISA kind of looks at fiduciaries in a couple different ways. First of all, you can have entities that are named fiduciaries, right? So obviously, if you come and say, hey, I'm a fiduciary of this plan, then ERISA considers you a fiduciary. And then also by statute, we know, for example, that the plan sponsor, again, is automatically a fiduciary. Now, we don't have statutorily a reason why a broker would be just a fiduciary, right, off top. However, the second part of kind of the analysis as it pertains to fiduciaries has to do with whether or not you are basically exercising any discretion over any of basically the actions of the plan, right? And so this is where sometimes brokers can kind of dilly-dally into fiduciary status and don't realize it, right? And so, for example, on the health and welfare side, sometimes I will run into brokers who will take responsibility for doing enrollments in the plan or deciding eligibility in the plan. In which case, you have just made yourself a fiduciary because you have the discretion to decide whether or not somebody is actually eligible for these benefits,
Hmm,
right? And I know a lot
interesting.
of brokers look at it as my client needs the help. They're small, maybe their HR, group is not big enough to kind of handle some of these things. And that's all well and good, right?
Right.
But it does kind of put you into fiduciary territory. And so you want to, I think, as a brokerage, make some decisions about kind of the services you're offering and figure out if there are ways that you're kind of stepping into fiduciary territory if that is not something that you intend, right? This is different from on the retirement side, where most retirement advisors are automatically fiduciary by statute.
Mm,
And if they're not by statute, they're going to say that they are because they're making certain decisions for the plan. But health and welfare workers can also kind of get into that fiduciary status and not really realize that that's what they did if they have any discretion over anything. Okay. And so keep in mind also that from the standpoint of kind of compensation and disclosure, when you start to talk about certain conflicts of interest as well, if a broker kind of makes certain decisions and doesn't disclose, let's say some of those conflicts, and that also kind of puts them firmly into fiduciary territory because they're kind of recommending something to the plan, but not being forthcoming exactly about what the plan sponsor should know about their relationships, right?
right.
So there are kind of ways that brokers do that. But I think for the most part, brokers can steer clear kind of that fiduciary label, right? As long as they are careful with those things. But I think that brokers still need to be very aware that this is going on. And I think where brokers bring the most value for employers is being able to communicate effectively to employers that they are fiduciaries, that the plan is, or the plan sponsor is a fiduciary, right? I can't tell you the number of companies and even brokers that I've worked with who the broker doesn't even realize that the plan sponsor is a fiduciary, right? And that just, we cannot have that anymore, right? So brokers, educate yourself on this topic, know that your plan sponsor is a fiduciary, and then know how to help them if they need to take additional steps to come into compliance from a fiduciary standpoint.
Yes, I think that's so important to help educate your clients. They first and foremost are a fiduciary, even if they don't call themselves that. It's not a name or a title. It's a job function essentially. It's a function. And so we have to help them to understand that yes, you are a fiduciary even if you don't know it, and that what does that mean for you beyond the fact that you could be named in a lawsuit or potentially personally liable. But
Right.
what does that mean for you as far as conducting this prudent process, going through these steps, documenting, really, really examining these service providers is key here, and their costs, claims costs, et cetera, is going to have to be the new normal, just like it would be for your retirement plan.
Absolutely.
Yeah. So I think this is really important as just some key takeaways for our broker community and employer plan sponsors that are thinking about this case and wondering how it impacts them. So would you just give some final thoughts before we wrap up today on where you think this is going to go in the future
Sure.
and any last, advice you would give to the audience watching today?
Sure. So as I mentioned earlier, the plaintiffs and defense bar are going to fight this out. And frankly, being a fan of ERISA, I don't think that ERISA is going to land at the idea that employer plan sponsors have to know that every single cost under their plan is the absolute lowest it can be, right? That's never been the standard of ERISA. I think once this lawsuit settles and once kind of the dust settles around these type of lawsuits, it's not going to be that. It's going to go back to kind of what ERISA meant at the beginning, which is that employers, as they are making decisions on behalf of their employees, need to do so from an informed place, right? They need to have that prudent process. And really, the service providers that serve those employer plan sponsors need to be in the same kind of frame of mind, right? And so everyone needs to be encouraging these employers to take steps that are prudent and that show that they are trying their best, right? To basically provide the best possible benefits to their their employees and plan participants. And that doesn't necessarily, again, mean the cheapest benefits. It just means the best benefits to them and that they are able to actually show the steps that they took to make sure that that is the case. Now, the final thing I'll say, frankly, is that, we're talking about kind of fiduciary due diligence and governance, and this being a new conversation to plans. But I think on the health and welfare side, before we even get to that, which is very important, a lot of the benefits compliance things that should have been done at this point need to be tightened up even more, right? So like at this point where we're talking about having to actually look at the benefits that are offered under the plan and whether the decisions on those are being done appropriately, it's kind of time out for you offering COBRA appropriately, right? Or inappropriately, right? Like you need to be making sure whether you're an employer plan sponsor or you're a broker, that the compliance things that we know that you should have been doing at this point for decades are buttoned up and in really good shape, right? Because as these lawsuits start to come up, they're not all going to involve PBMs, right? They're not all going to involve, let's say, the medical costs under the plan. Some of them are just going to be, hey, employer, you don't meet any of the compliance obligations that you're supposed to do, right? And so I think it's really important for employers to access, services like the ones that you offer, Sarah, at BCS, right? And to come to ERISA counsel like myself when you need to, because it really is time out for you kind of just having things that you could be doing correctly, not go that way. And so that's kind of my final thing.
Yeah, absolutely. So last question, Beth, who should contact you in our broker and employer plan sponsor community today? And at what point would you say they should contact you for help?
Sure. So, I'm an ERISA attorney, and I kind of like to think about ERISA attorneys versus, let's say, benefits compliance professionals. Sarah and your benefits compliance professionals are going to be that compliance, really just maintenance, right? Like everyday kind of things that you're going to need help with on compliance. You're going to go to someone like Sarah. For me, I am more of like when you have to go to someone who has to like triage a situation, right? Or help you
Right.
stand up your fiduciary governance processes, right? And so that is something that I can assist with, whether you're an employer plan sponsor or whether you're a broker who may need some assistance from ERISA counsel in setting up their fiduciary best practices. And so that's kind of what I would say about that. And again, I'm really appreciative to be on this conversation with you today.
Yes, thank you so much, Beth, for your insight and all of your knowledge. I really was excited to talk with you today. So, all of those listening today, yes, please reach out to Beth Allen and her firm for assistance with these various issues. If you need great ERISA counsel, she is the one that you need to call, especially with health and welfare, of course, but retirement plans. And contact us if you need support from the agency side with all of your clients. We work together a lot. So appreciate your time today, Beth. If anyone has any questions, please feel free to reach out and we can respond to those. But in the meantime, everybody help your clients and let's try to tackle this together. Thanks so much.
Sure. All right. That was